Okay, so good afternoon, everybody. My name's Erin Shahinfar. I'm an attorney in the advanced planning practice, which is subunit of the public benefits unit at New York Legal Assistance Group. And this is the training on the Guardianship Alternatives Legal Clinic. Hey, Wilma, do you mind muting yourself? I think there's a little feedback. Okay, awesome, thank you. So yeah, we're doing the training today, November 14th, but the clinic is taking place this Saturday, November 18th at our community partner, Include NYC. Briefly, NYLAG, we're a nonprofit civil legal services organization. We obviously provide legal services, but we also do financial counseling and policy advocacy for New Yorkers experiencing poverty. So this is the agenda for our training today. So the purpose of the clinic is to help young people with disabilities make guardianship alternatives. So first, in order to talk about what alternatives to guardianship are, I'm going to start by talking about guardianship. What is this? Why do we need alternatives to it? After that, I'm going to talk about what materials are going to be available on the day of the clinic, and then I'll walk you through the different documents that you can help clients make. And finally, we'll talk a little bit about some of the clinic checkout logistics.
Okay, Erin, just wanted to let everybody know here, you mentioned that our partner is Include NYC, and then our firm partners are Trauma and Pepper. Everybody's there. Madeline, if you want to welcome your team. And we also have Show Roth in this as part of this clinic, and both three teams are going to be together, 2 law firms and our partners at Include NYC. You probably want to say something, Madeline and Sarah, if you're there. And I think Ebony is also there.
Hi, it's Maddie at Trauma and Pepper. We are all very excited to learn more about how we can help, and we're looking forward to Saturday. Thank you.
Hi, yeah, this is Sarah. I'm also very excited to have our folks participating, and thank you for putting this on. We look forward to many more.
Hi, everyone. Ebony Innes from Include NYC. I'm here with my team from the Youth and Transition Services team. And I just want to extend a very heartfelt thanks to everyone who was a part of this collaboration. This is our first endeavor with the youth clinic, and we're looking very much forward to it. So thank you.
Thank you.
Yeah, thank you guys so much. And thanks everybody for participating. I'm truly passionate about this work and serving this particular client, this client group in particular. So hopefully after the presentation and after participating in the clinic, everybody will also understand why. All right, so I'm just going to dive in because there's like a little bit of ground to cover. So the first thing is, okay, what is guardianship? So when somebody turns 18, the law presumes capacity. So an 18-year-old can generally vote, marry, sign a contract, obtain medical treatment without parental consent, live where they want to live, manage their own public benefits, hire an attorney. There's also certain privacy laws that of course apply when somebody turns 18. So these are things that protect like financial, medical, education records. Are all 18-year-olds ready to take on absolutely all of these rights and responsibilities? The answer is no, whether or not somebody has, a disability. This is usually like a gradual process for most people. They turn 18 and as they get more skills and, learn more about the different decisions they have to make, they kind of gradually take on more responsibility. But of course, most young people have some sort of an older adult who they look to for guidance. And then I also have a quote that I hear a lot from clients, which is, my child has a disability. I was told that I need guardianship to keep helping them once they turn 18. Is this true? So no, this is not necessarily true. You don't necessarily need a guardianship in order to help a young adult with a disability. So there are two pathways when there's an adult with a disability. One pathway is guardianship. This is created by a court. This is a court process. And the other pathway is alternatives to guardianship. These are different legal documents like powers of attorney, healthcare proxies, information releases, Social Security representative payees, for example, that's another alternative, trusts, ABLE accounts. There's so many different things in the wide world of guardianship alternatives. Now, which pathway do you go down? This kind of turns on the ability level of the person with the disability. So if the person with the disability is able to communicate and make decisions for themselves, then they can do alternatives. And a court-created guardianship is not going to be necessary or appropriate. So further, what is guardianship? Guardianship is kind of like having a moment, I guess. So we've got Britney Spears, we have Michael Oher from The Blind Side. So guardianship on a fundamental level, like this removes legal rights from one person and gives them to another person, the guardian. Like I mentioned, it can only be created by a court, and it is considered a remedy of last resort. So it is the most restrictive legal option for helping a person with a disability. Typically, it requires a finding of incapacity, but not always. And there's a lot of variation from state to state in terms of the laws that govern guardianship, okay? So what is guardianship like here in New York? There are two kinds of guardianship here in New York. There's 17A guardianship, and this is created in surrogates court. It has its own terminology. The surrogates court guardianship is a plenary guardianship. So what that means is that it's total. It's like a light switch. Like if you are under guardianship, you have had your decision-making rights removed. It is not tailored. 17A guardianship is also very diagnosis-driven, and quite honestly, the statute hasn't changed a lot since it was created in the late 1960s. The other kind of guardianship, I'm not really going to dwell on here because it's less relevant to our client population that we're going to be serving at this clinic. But the other kind of guardianship is Article 81 guardianship. It's created by the Supreme Court, and it is a tailored guardianship. It is a lot less diagnosis driven. But I have 17A circled because that is for young people with disabilities. Their parents and they themselves might be hearing quite frequently, like, you need to get guardianship, and this is what people are referring to. This plenary total guardianship, the total removal of rights. Again, I'm not gonna dwell too long on this, but so for the legal standard for 17A guardianship is, you have to prove to the court that a guardian of the person is in the best interest of the person with the disability. There are a few different elements that have to be shown. In 17A guardianships, they want to see that the diagnosis occurred before the person turned 22. They have to have a diagnosis of either intellectual or developmental disability. And they also have to show the court that, the person with the disability is incapable of managing themselves and their own affairs. And also that the condition is permanent. This is a permanent diagnosis that's not going to change. And then the final, and I think one of the most important elements that has to be shown in order to create a guardianship, in order to remove someone's rights, is you have to show that the guardianship is necessary. And so what this means is that there are no less restrictive means that are going to meet the needs of the person with the disability. So, here, when is guardianship necessary? When a person can't communicate or make decisions for themselves, there is some sort of decision that requires legal authority that needs to be made. No one has the legal authority to make that decision. And again, for the purposes of this presentation, most important is that guardianship alternatives are not possible. And the guardianship is the last resort to meet the person's needs. Okay, so concluding thoughts as we are defining guardianship in order to then kind of like talk about the purpose of the clinic, which is alternatives. So guardianship removes legal rights from one person and gives them to another. It's court created. It is generally permanent. So it lasts until the person with the disability dies or the guardianship is removed by the court that created it. Guardianships are potentially time-consuming, expensive, and invasive. And then finally, you have to prove to the court the necessity of the guardianship. There are no alternatives that are going to work in order to meet the needs of the person with the disability. Okay, so what are alternatives to guardianship, and why am I an evangelical about alternatives to guardianship? So these generally do not remove decision-making rights from the person with the disability. So the person with the disability remains the decision maker. They are not created by a court. They are generally not permanent. They can be canceled or changed by the person with the disability as they acquire new skills. So alternatives to guardianship can grow and change as the young person, as their needs change, as their abilities change. They're much more flexible than guardianship. They are less time-consuming, less expensive than guardianship. And again, the purpose of this clinic is to help young adults with disabilities make guardianship alternatives so that they can maintain their decision-making rights while receiving help from people that they trust. And also they're able to define the kind of help that they want. Okay, so hopefully that, we kind of flew over it, but hopefully that was helpful in laying the groundwork as to this is what guardianship is, this is what alternatives are. And the purpose of the clinic is not guardianship. So, on the day of the clinic, you will come to include NYC, and there will be tables set up. And at each table, this is where, attorneys will meet their clients, and also they'll meet the young person's family as well, or whichever family members the young person brings with them. And at each table, there is going to be a client folder. So here's what's going to be inside the folder. First of all, there's going to be a clinic checklist. This is just going to guide you through client counseling for the clinic. You don't have to stick strictly to the checklist. It's just based on, typically how these counseling sessions go when I work with young people. And it will help you gather the information you need to make recommendations and to counsel the client and their families. The next thing that is going to be in the client folder is a limited services agreement and a family acknowledgement form. The purpose of this is just to make it extra clear to families and to the young person who is being served by the clinic. And in this case, again, it's the young person. The young person is the decision maker. So they will be the ones who will sign the agreement saying yes, I want to participate in this, which, everybody's been screened. They've all expressed that they want to do this, but this just kind of helps formalize that. And then the family acknowledgement form basically just says, I am a family member. I understand I am not the client. I am not being provided with legal advice. So family members, if they stay for the consultation, which is up to the young person, if the young person wants them to do that, which, I mean, again, I've spoken to everybody who will be attending the clinic, and they've all expressed that they want their family members to be there for the consultation, which is very typical. So if they confirm that that is still, what their wishes are, then the family member can stay, but they need to sign this family acknowledgement. There is also a questionnaire. So the questionnaire is going to help you identify which alternatives might be appropriate for your client. The questions in the questionnaire are, like, they ask about different areas of the client's life, their finances, are they in school, are they working, do they have public benefits? And as you kind of gather this information, you'll be able to talk with them, talk with their family members about, okay, what are we kind of already doing here in order to help the person with the disability? And at that point, then you can kind of make recommendations about what documents the young person might consider making. The fourth item in the folder is a clinic menu. Basically, this is just a very quick and easy description of the different documents that will be available to the young person. And we'll walk through what each of those are and how to do them in this training. The fifth thing in the folder is a forms packet. This is just blank forms. So the documents that we're offering, these are blanks and backups. And in terms of the forms, you can just handwrite the client's information into any of the forms that they want to make. And then the last thing that's going to be in the packet is sample forms. So I myself am a visual learner, so there will be completed forms in there so that if you can see what a filled out information release would look like. And it might be a quick way to just double check that you're checking the necessary boxes and inserting the necessary information. Okay, so I'm gonna take a sip of water real quick. Okay, so what documents are going to be offered at the clinic? We're going to offer 5 documents to people. And they're arranged here. The first 4 are arranged here in terms of difficulty. So the first one is a HIPAA release. HIPAA is the acronym for the law that protects medical information. And so this would allow a young person to give someone they trust permission to access their medical records and information. The second one is a FERPA release. FERPA is an acronym for the privacy law that protects education records. So this would allow a young person to release education information to someone they trust. A healthcare proxy lets a person appoint a medical decision maker in the event that they are incapacitated. The fourth one is a power of attorney, which probably, all of you guys are familiar with. This lets somebody appoint an agent to make decisions for them related to insurance, bank accounts, public benefits. And then the last form that we're offering would really only be necessary if somebody doesn't want to make a power of attorney or can't make a power of attorney because maybe it's too confusing of a document. So the last one is called a Medicaid authorized representative form. This is if somebody has Medicaid and they want to appoint an agent for Medicaid purposes only. Okay, so as I mentioned earlier, our practice is we're just going to handwrite information. We'll handwrite client and their agent's info in clear legible handwriting. just make sure to double check their name using their photo ID. You'll also include agent information, and you can Google people's addresses just to make sure that everything is correct. I do this on a regular basis when I'm meeting with clients with or without disabilities. We're going to use a black pen. You know, if you make a mistake, like we're going low tech, if you make a mistake filling out a form, or if client signs in the wrong space, that's fine. Just swap out one of the pages. And finally, please don't staple the documents together until after, you know, I've reviewed them, or my colleague Maria, who's also going to be at the clinic, until either of us have reviewed the documents and just made sure that, like, you know, just taken a last look, because there are different places to sign and insert information. So you can just use a paper clip in the meantime. All right, so I'm just gonna keep moving ahead. So the first document is a HIPAA release. Like I mentioned, this lets a young person, or any person really, give permission to someone they trust to access their protected health information. Protected health information is, you know, this is related to like what healthcare they're receiving. This could be related to payment of expenses for past, present, or future healthcare. And yeah, this could also be information about any conditions they might have. This document does not allow somebody to make decisions for you. This only allows them to access medical information. That's it. It can be revoked at any time. And the HIPAA release is effective from the moment that it is signed. So unlike the healthcare proxy, which we'll talk about, you know, that document is triggered by somebody losing capacity to make their own decisions. HIPAA release is different. As soon as you sign, basically it's in effect. So this is a sample. I'm sure the font is very tiny, but that's fine. We're going to go through it. Basically, this is a one-page document, super, super simple. It doesn't even have to be witnessed. You will just be guiding the client, if they choose to make this, through the necessary kind of like portions to sign, and helping them put information in the correct places. Okay, so to complete a HIPAA release, like I said, this is a super simple document. You'll include the client's name, date of birth, and their address. You'll review parts 1 through 6 with the client, which basically just describe what the document is and what it does. Part 7 is a general release for all entities under HIPAA. So that has been pre-typed into the form. We are not making these specific to healthcare providers. These are just general releases. And part 8 is where the young person will include the information of their trusted individual or individuals who they want to be able to access their information. So on the prior slide, we were looking at Bart Simpson's HIPAA release, and here we have an excerpt. He has designated Marge and Homer as the people who can access his medical records. Okay, so the young person, if somebody tries, or if somebody chooses to make this document, they can designate what records they want to release. Typically, you know, so under 9A, they can say, I only want to release medical records from like this particular time period. Or they can say, you know, they can create some other restriction and say, I only want records from like this particular doctor or something like that. But generally, what I'm doing for clients is they're just releasing their entire medical record. So this is like patient history, office notes, test results, radiology studies. It basically like lists, what all this entails. So typically for when I'm counseling young clients, we just are doing a general release of the entire medical record. There are certain records that are extra protected, and I always tell clients this. So certain records that are extra protected are things like alcohol and drug treatment records, mental health information, and HIV-related information. So if clients want to release that info to their trusted person, that's fine. They just have to initial, they just have to initial over here where Bart has written his initials. And the other thing I would say is, like, when I talk to clients about, most of them are fine understanding the concept that certain records are extra special. But I also make sure that they understand what these records are. Some clients who I've counseled about these documents, they may not know what alcohol and drug treatment records are. They may not know what HIV-related information is. So be sure to just check in with the client and make sure that they understand. And one way that I do that when I'm counseling young people is just, have you heard of this? If they say yes, then I say, okay, great. Like, tell me what you've heard. Tell me what you understand about alcohol and drug treatment records. If they say no, then we discuss it. Then we explain it and see if this is something that they want to release, and make sure that this is something they understand. Okay. And yeah, for part 9B, this is essentially kind of like, it's kind of repetitive, but this is where the person signing has to initial, that they are authorizing their healthcare provider to release information to their trusted person. Okay, the end of the document. So, these documents are being released at the request of the signor, the individual. So you'll just X in that box. The date or event on which this will expire, we'll just put upon revocation. So it's up to the young person. Just make sure that they understand that, like, they can cancel this at any time. It's very simple and easy to do. They just have to talk to their healthcare provider or whoever has a copy of the document. And then when they are done, the young person can sign and date at the bottom of the document. No witnesses or notaries required. Okay. And this is like a good one to start with, because it's very, very simple. It's an extremely simple information release, and it does one thing. So I usually start here when I'm walking clients through documents and assessing kind of like, okay, what is going to be appropriate here? And also, what does the young person understand? Every person that we are counseling at this clinic has, they have different disabilities. Some of the clients do have intellectual disabilities, so you will want to really make sure that you're checking in with the client and making sure that they understand and that they know what they are signing and that they understand what the purpose is. Okay, a FERPA release, very, very similar to HIPAA release. This just is an information release for education records. So the young person, once again, can pick and choose what records they want to release to their trusted person. And again, this document is super easy to cancel. So the young person should know that, this doesn't allow anybody to make education decisions for them, and they can cancel it at any time if they don't want their trusted person to be able to access this information in the future. Okay. So a FERPA release is actually easier to fill out than the HIPAA. It's very, very simple info. So again, you'll just include client's name and then whatever education institution they might be attending and the name of their trusted person. This document may not be appropriate for all clients. The age range varies a little bit in terms of the clinic attendees, and some of them are not attending school right now. So if that's the case, there may not be a reason for them to complete a FERPA release, or they may say, yeah, I don't want that, and that's fine. But if somebody does choose to make this document, they will choose what records to release, basically they'll explain the reason for the release, and then they will sign and date, again, no witnesses, no notaries. That's it. And yeah, one final thing about the FERPA release. It's similar to a HIPAA release. It's a one-page document, and like I said, it is very simple to fill out. The HIPAA even has some places where you need to check in with the client and really make sure they're understanding, or there are places where people might initial or sign in the wrong spot, but not on the FERPA release. The FERPA release is very simple. So I didn't include a picture of it in this presentation, but you can take a look at it in the pro bono materials that were hopefully sent around. Okay, so moving on to our third document, this is a healthcare proxy. Many of you may be familiar with this document already. So this is a legal document where someone can choose a person they trust to make medical decisions for them, if and only if they can't make decisions themselves. So it takes effect when a doctor certifies in writing that the signor, the principal, lacks capacity to make their own healthcare decisions. This, and when can somebody not make their own decisions? Obviously, if they're in a coma, but this document also could be triggered if somebody is in psychosis. And if that is the case, if a doctor is determining that a person can't make their own decisions because of a mental health condition, they actually have to consult with another provider, either a physician or a PA, physician assistant, or a nurse practitioner to confirm this determination. So in that case, there basically have to be two medical professionals who agree, yes, this person can't make their own decisions right now. You can only have one trusted person serving at a time. And so on some other documents, you can have two people who have powers at the same time. Not on the healthcare proxy. You can have one person who's the decision maker, and you can list a backup if that first choice is not available. And the healthcare proxy can be canceled at any time by the principal. So I'm going to go quickly over this section. So if somebody doesn't have a healthcare proxy, there's actually state law that sets out a default order of who can make decisions for an incapacitated person who's in a hospital or a nursing home. First, and I've listed the order there. First is a court-appointed guardian. Second is a spouse. Third is a son or daughter who's an adult. Fourth is a parent. So for the clients that we're counseling today, or not counseling today, but for the clients that we are counseling on Saturday, if they do not make a healthcare proxy and something happens to them and they go to a hospital and they can't make decisions for themselves, it is going to be a parent who would be able to make medical decisions for them. Now, that often will lead clients sometimes to asking, then why would I ever do a healthcare proxy if there's default law? So the reason to make a healthcare proxy is that the Family Healthcare Decisions Act, which is the default state law, is limited in terms of where it applies. It only applies in hospitals or nursing homes. So it's not going to apply at the dentist. It's not going to apply at like outpatient treatment facilities, things like that. The Family Healthcare Decisions Act also sets out a default order of who would be the decision maker for a person who has lost capacity. That is not always everybody's wish. For example, you know, like I said, the default for the young people we'll be counseling will probably be their parents, but they may have a brother or sister or another relative who they trust and feel closer to and want to be the medical decision maker instead. And yeah, also the Family Healthcare Decisions Act can lead to conflict if there are multiple people in particular classes that are entitled to be the decision maker. So healthcare proxy applies more places, and you can choose who you want. It can be anybody who's an adult. And it also sets out specifically who you want to be the decision maker. So it eliminates potential conflicts. So how to complete this document? A healthcare proxy is also a very simple document to make. There's not a ton of information that you need, but the most important thing is that you're going to be counseling the client through what this document does and through their choices of people to list on the document. So it's going to be like it is like counseling heavy. So you'll include the name of the principal, so the person signing, the young person, as it appears on their government issued photo ID. I don't think this is an issue at this particular clinic, but it has come up before. If the person has multiple names or they've had a name change or something like that, you can list their other name as an AKA. That's no problem. So on the form, they'll be listing someone they trust to be the decision maker if they can't make decisions themselves. And you'll just want to, talk to them about this choice. If that person is there, you'll want to talk with that person too. And you can say, the way that this works is like you need to carry out the wishes of the person who has signed the document, the young person. You're not able to just do whatever you want. You need to be carrying out the young person's wishes. You can ask the client if they want to appoint a backup. That is ideal, but not everybody has a backup agent who they want to list. And then you'll need to have the name, the address, and the telephone number of the agent, and also, whoever they want to list as their successor agent, their backup. So once again, this one was created by Marge. So this is just a snapshot of Marge's healthcare proxy. She is named Lisa as her agent. And then she has Bart as her successor agent or her backup. Okay, so moving further into the document, for section 3, you can list an expiration date on the document. I think I've done so many of these, and I think only once I've ever listed an expiration date because the client just wanted it to last a year. After the year, they came back to me and we redid it because they said, okay, I don't want an expiration date now. If there's no expiration date, the document is good until it's canceled or the person who signed it has passed away. So our recommendation is usually don't list an expiration date, just leave it blank. And like I said, that means it's good until it's canceled or the person passes away. Section 4 is a space where you can include special instructions. We are going to have a pre-printed phrase that says, I have discussed my wishes concerning artificial nutrition and hydration with my agents. So make sure that client understands what this means. Usually I will ask them, do you know what artificial nutrition and hydration is? Usually they will say no. At that point, we will talk about whether they know what a coma is. Often people do know what this is. I'll tell them, like, when your brain is asleep, like, you're not able to eat or drink. So it is possible for doctors to keep your body alive by giving you food and water through tubes. Sometimes people have very strong opinions about this. Some people are okay with receiving food and water this way, and some people say, no, I definitely don't want this. Just let me go. So have a conversation with the young person about what they would want. The reason why this pre-printed phrase is there is it's from case law. The agent can make decisions related to end-of-life care so long as they know what the signor wants. If like the young person doesn't understand, or this isn't like making sense to them, or they don't want to include this phrase, that's fine. This phrase can be eliminated, and you would just tell them, this document gives the person you trust power to make end-of-life decisions, so long as they know what you want. So you should have a conversation with them. Okay, so the client, if they agree with the statement, they'll just initial after the pre-printed phrase. Okay, parts 5, 6, and 7. This is basically the ending of the document. Part 5 is a HIPAA release, so that if someone can't make decisions for themselves, their agent can talk to doctors, get medical information related to them so that they can make informed decisions. Part 6, the principal signs and dates. And then part 7, the signing and dating has to be witnessed. Now, on the day of the clinic, you will be paired up with another attorney. So there should be 2 attorneys at each table, meeting with the young person. And both of the attorneys can be witnesses. That's no problem. And you can just use your work address as the address that the witnesses have to sign, put their address, and also date. So once that's done, the document is complete. Okay, so there's Marge's signature and date. And then this is the entire document. It's a 2-page document. And the witnesses were Selma and Patty. So they both signed, dated, and put their addresses. Okay, I'm going to pause for the CLE code, which is Troutman 90. This is the first CLE code. Okay, so please record that somewhere. Okay, Troutman 90. All right, moving on to the 4th document. Oh, sorry,
Erin, I just also want to, for the folks from Schultz, so I made sure that if the CLE code for them is, I'm gonna also put it on the chat. It is
okay.
ELSOCP, again, ELSOCP. That is for the Schultz attorneys on the meeting.
Yeah, Wilma, it was really hard to hear you for that.
Okay, can you hear me there? So the CLE code for the.
No, we can't hear you better.
I put it on the chat.
Okay. Okay, so the CLE code for the is also in the chat for everybody. Okay. All right, so the next document is the power of attorney. This is like the beefiest document that we are going to counsel clients about. This document, so in this document, the signor, the young person, can choose a person they trust to manage their financial and banking matters during their lifetime. So unlike the healthcare proxy, which is triggered by incapacity, this document is effective as soon as the principal signs and as soon as their agent signs. Once those two things happen, then it is functioning. It's a powerful document. I always tell clients you need to trust your anybody you list on it completely. And once again, it's a durable document. So like, if somebody loses capacity in the future, the document is not affected. So this document, like everything else we're making at the clinic, can be revoked at any time by a principal who's competent. The young person is not signing away their decision-making rights. And I tell that, like, if I'm counseling parents and young people, I always explain how this document works. Like, this is not a blank check. The person who is signing it, so their agent, whoever their trusted person is, has to follow their instructions so long as they can give them. If they do not follow the instructions of the principal, then the document can be canceled. And if they, for example, like take money or do things that principal doesn't want, they can be taken to court and basically sued to get the money back. If they can't give instructions anymore, then the agent has to do things in the best interest of the principal. So you can't have a conflict of interest or things like that. The power of attorney is only effective during the lifetime of the principal. So it stops when it's either canceled or the person passes away, the signor. Okay, I know our time is running out, so I'm going to breeze over this. Principals, so everybody who's attending the clinic is an adult. They're over 18, so they can sign. Capacity is determined at the time of signing. Okay, so there's a range of, the clients have a range of diagnoses. Some clients have like full capacity, like absolutely like no, they have full capacity. So what that means is that they should understand the document. You just need to explain it in a way that makes sense to them and that they understand. There are some clients with intellectual disabilities, and you're going to want to really like check in and make sure that they understand and that they do understand what this document does and that they're able to do it. Okay. So the principal has to understand the nature and consequences of signing this. They need to understand they're giving power to do something to someone else. They need to understand that they can cancel that power. They need to understand any provisions that they're signing in the power of attorney. Like they could make a very, very narrow one. For example, if they just said, I want my mom to deal with public benefits for me, and I'm only going to sign that one power, that's fine. They could do that. But they need to understand what that power is. And like I said, that it can be canceled. Yeah, and they need to understand that this person can base whoever they're listing as their trusted person can go out and do things on their behalf. Agents, they need to be over 18. They have to avoid conflicts of interest. Like I said, they're a fiduciary. So the way that it works is I always tell clients, you know, you're in charge. You give instructions to whoever you're listing on this document, right? They need to follow your instructions. If you can't give instructions, then they have to do things in your best interest. And then I always tell the agent, like there's, and a lot of people don't know this, you have to sign in a particular way if you're using this document. So for example, if James Smith has made a power of attorney, the way that he would sign, so if Julia Smith has made a power of attorney naming, you know, her husband James Smith as agent, then what happens is he needs to disclose that. So James Smith as power of attorney or agent for Julia Smith. Okay. Completing a power of attorney, you will need to explain to the client how this works. You'll need to print their information, their name as it appears on their ID, their address. You'll have to explain, you know, so on a power of attorney, you can list two people, up to two people to have power at the same time. So you'll want to make sure that, you know, you'll want to see if that's something they want to do, or do they just want one person and a backup? If they list two people to have power at the same time, then we always recommend that they initial a section that says the agents can act separately. The reason why is because, for example, at the bank, like everything they do has to be in lockstep, which can be administratively really, really challenging for people. Like every check has to be signed by both of them. Every call with the bank, both of them need to be there. So if somebody's listing two people to have powers at the same time, like mom and dad, we also want to recommend that they initial that mom and dad can act separately. So here's a sample. Bart is named Marge and Homer, and he has given them permission to act separately. Okay. Sections D and E, these are on a page by themselves. You'll just advise the client of this information, which is that, you know, the document is not affected by incapacity, and that they can revoke it. And if they've made a prior POA, there's a place elsewhere in the document where they can cancel that. So completing a power of attorney. So there's a grant of authority section, and this is where the clients can pick and choose what powers they want to give to someone. These powers, they'll need to initial at every power. They can't do a check mark, can't do an X, have to initial. Okay, so like here's a sample. Bart picked, he chose different powers that he wanted to give, and he wrote his initials next to each one that he wanted. It is also possible to list all of the powers at P. So Bart could have also done, you know, A, B, D. We could have typed everything out here, and then he just initialed one time. But I find it's actually, like, for young people, it's easier to explain each power one by one, and then every one they want, they just write their initials next to it. Okay, so I am, again, like, I'm aware that time is running out, so I'm going to try to fly through what these different grants of authorities do. Most of them are intuitive, not all of them. Okay, so the first one, A, real estate transactions. I don't think any of the clients attending this clinic are going to own land or property of their own. However, real estate transactions, if you initial this, you can also give your agent permission to sign a lease on your behalf. That is what is going to be most applicable to our young clients. So that is how I would explain that one to them. None of them own land or property on their own. B, chattel and goods transactions. I always ask clients if they know what chattel is. Nobody does. This is just fancy lawyer word for stuff. So I explain to clients, you know, like if you want your agent to be able to sell like a TV or furniture or like anything movable for you, if you want them to buy or sell these things, then you would give them B. C, bond share commodity transactions. You know, you can open it up and ask the client if they know what stocks and bonds are. They may, maybe they do. They may not, in which case you can describe kind of what these do. Their parent, if the parent is participating in the consultation, may also, you know, be able to help weigh in. They may say, oh yeah, like you inherited some of these from your grandma or whatever. But if they want to give their agent permission to buy or sell stocks and bonds in their behalf, they would include C. D, banking transactions. This one's going to be applicable to clients if they have their own bank account. And that's something that's in the initial questionnaire. You know, do you work? And that will tell you kind of whether the client has a bank account of their own. If they want to give their agent permission to open, close, make deposits, withdraw from bank accounts, they can initial this power. If they do not want to do something like that, if they say, no, I really don't want them to have that power or ability, that's fine. That's also extremely normal. If they just want to give their parent like permission to see what's going on in their personal bank account, they could, then you can just advise them to talk to their financial institution and they can sign, you know, a financial information release. But this would allow the parent to do, or the trusted person to do different things that would affect the account. E, business operating transactions. This would let the agent basically run a business if the signor owns a business. So this would let them run a business on their behalf. I've done, I think, hundreds of these documents. I've literally never met anybody. None of my clients have ever owned a business, but this could be applicable if somebody is like Etsy or something like that. Okay, I know that I'm going to go slightly over time. If you have to jump off of the call, that's totally fine. This is going to be recorded and, you know, we'll share out the presentation afterwards. But I'm gonna press on, and I apologize that this is going a little bit longer than the time we had allotted. Okay, F is insurance transactions. This is really going to be important for our clients. This would let the agent pay premiums, modify, rescind, terminate, like any kind of insurance. So this could be health insurance, life insurance. If they're getting like, if they have car insurance, this would let the agent deal with any of those policies for them. G, estate transactions. This is sometimes hard to explain to young people, and this one is not intuitive. This would let the agent handle property and affairs of a deceased person on behalf of the principal. So what does this look like? The way that I usually explain this one to clients is like, okay, if you have a relative, like an aunt or an uncle or a grandma or somebody like that who passes away and they leave you money, in order for you to inherit the money, there may be documents, court documents, surrogate court documents that you would need to sign in order to receive that money. If you give your agent power G, they can sign those court documents for you so that you can receive the money. That's usually how I explain that one, and quite honestly, that's usually how that one G would play out. H, claims and litigation. This would let the agent hire an attorney on behalf of the principal. They could also prosecute any cause of action, claim, counterclaim, or defense on behalf of principal before any court or administrative board. They could also settle a case. Basically, the only thing that you couldn't do on behalf of somebody is you can't initiate a divorce proceeding for the principal. Okay, I is not intuitive. So this permits an agent to do, basically this lets the agent give up to $5,000 in gifts that the principal has given customarily throughout their life. So I always give examples of this one. Like, for example, if you have a niece or nephew and every Christmas you give them $100, this would let your agent continue that gift for you. So the agent could give your niece or nephew $100 if it's their birthday. They can only give gifts that you have given throughout your lifetime. This one is like not super applicable to young people, but it's important to explain it and see if this is one that they want to include. It also includes like charity too. Like if somebody gives a certain amount to charity every year, this would allow the agent to continue that charitable gift. J, benefits from government programs, civil or military service. This is super important for our clients. This would let the agent manage public benefits on behalf of the principal. So they could go to a fair hearing, they can talk to, you know, the different agencies that administer public benefits. The one limitation is that this does not apply to Social Security. And like many parents and clients wonder, you know, okay, like, is this power of attorney? I'll just show it to Social Security and then, you know, I'll be able to manage those benefits. No, Social Security has their own process. And basically, if somebody wants to manage Social Security benefits for a young person, they need to talk to the Social Security Administration. And Social Security will go through their own investigation and appoint, you know, whoever they think is appropriate. But this power of attorney, you know, is not going to guarantee or even give you access to manage somebody's Social Security benefits. K, matters related to healthcare. This would let the agent pay healthcare related bills on behalf of the principal, so hospital bills. L, retirement benefit transactions. This is another one that can be sometimes challenging to explain to clients. So yeah, this would let the principal contribute, withdraw, deposit funds from any type of retirement benefit or plan. These are very young people. They probably don't have retirement benefits at this point. Unless they're working, maybe they do. So yeah, you'll just want to talk through, find out if they understand what retirement is. If they understand that, then you can ask, you know, is this something that you want to include? If they don't want to include it, then that's perfectly fine. And we're approaching the end of the powers. So M is tax matters. This lets the agent prepare, sign, and file federal, state, and local tax forms. They can also submit refunds, claims, petitions. They can deal with all tax matters, basically. In all other matters, this is a catch-all provision. So the way I usually explain this to clients is like, anything else you ask your agent to do you want them to be able to do that? This is just a catch-all. And then the last one, O, full and unqualified authority to delegate any and all of the foregoing powers. What I tell clients about this one is I say, okay, all the powers that you just gave to your trusted person, if you give them O, they can then take those powers and give them to somebody else. is that what you want them to be able to do? Or do you want to just keep the document limited to, you know, your trusted person? So that's usually how I explain that one. And then P, this is just a blank, this is 2 lines. And this is where you could list all the powers if you wanted the client to just initial one time. Okay. So G is an acknowledgement section that is actually not going to be applicable to our clients who are filling out this particular power of attorney form. If you want to allow gifting on a power of attorney of more than $5,000, you have to initial here. But these powers of attorney that we're making don't allow gifting, so the client doesn't need to sign this section. Okay, there are like 3 optional modifications that the client can sign. The first one is if they've made a power of attorney in the past, they can initial in this section to revoke it. I would be shocked if any of these clients have made powers of attorney in the past, but if they have, they want to revoke it, they can initial here. The next one, so this grants authority. This just lists all the different public benefits here in New York City, and it's just a more specific version of Power J on page 3 of the grant of authority. And the reason why is just to help with ease of use, so that, you know, if somebody presented the document to HRA, HRA couldn't say, yeah, we don't know if like they really meant Medicaid benefits specifically. The next optional modification, this is permission to represent agent in any housing matters. They could submit income affidavits or sign leases, submit repair requests. Further clarification of A on the grant of authority page. The next one is permission to enter into, modify, or terminate personal care contracts. So someone could hire a home health aide or a nurse to come and take care of the principal if that's something they needed. Okay, so again, what I'm going to say is like this page, you can read this on your own time. This is just stuff that needs to be explained to the client. They don't need to sign, but you need to review this with them when they're completing the form. The principal has to sign and date in front of 2 adult witnesses who are not the agents. So again, the attorneys can be the witnesses. Principal has to fill out the date. They have to write it out November 18, 2023. Witnesses have to sign and date, and again, you can include your work address. And then the document has to be notarized. I'm a notary and my colleague Maria is a notary. So when you are ready to have this document notarized, you could just flag us down and we will be happy to do that. Or if you need a witness, the notary can also be a witness. Okay, so Bart wrote it out, he signed, and then it was notarized. Okay, the next CLE code is NYLAG 23. That's NYLAG 23 for the next CLE code. Okay. That's great. NYLAG 23, next CLE code.
The group from the CLE code again is ELSOCP. ELSOCP.
Okay, Wilma, it was like we weren't able to hear basically any of that. If you could drop it in the chat again, that would be awesome for the Schultz attorneys. Or if you want to message me, I can read it out.
It is on the chat.
Okay. All right. So yeah, please check out the chat for the Schultz attorney CLE code. So I'm actually going to skip the description of the Medicaid authorized rep form for now. What I will say is that, you know, as I mentioned earlier, this is the form that lets somebody appoint an authorized representative just for Medicaid benefits. So this is only going to apply if the young person A, has Medicaid, and B, doesn't want to sign a power of attorney. It's a pretty simple and straightforward form. It's actually two forms. One tells Medicaid, hey, I want to make a change to my account or to my file. And then the second form is like who you want to list as your authorized representative. There is going to be a sample of this form that's in your materials, and Maria and I will be circulating at the clinic. So if you do have a situation where you've got a young person, doesn't want to do a POA, has Medicaid, does want to do just this form, you can flag me or Maria down and we can help walk you through this. Okay, so in the interest of time, I'm going to fly over this. Okay, so here's how to check out of the clinic. When your client's documents are complete, please ask me or Maria to come over, and we'll just be like a second set of eyes. This is something I do all the time. Like I have my colleagues review my documents, they review, I have them review documents I've prepared, and then vice versa. I'll look over stuff they've prepared, just because there are many different little places to sign. Once you're done, please make 3 copies of all completed documents. You can staple the copies and the originals. Give the client 2 copies and the originals. The client keeps the originals and they keep most of the copies, but save 1 copy and put it in the client folder. This is so that NYLAG has a record of the documents that that have been prepared for the client at this clinic. If the client didn't come with their agent for the power of attorney, just make sure that they understand, the agent will have to sign separately on another day, and that's totally fine. They'll just have to go in front of a notary public. When you have put the copies of the document into the folder, you can just bring it to me, and at that point, then you'll be good to go. So in the folder, you'll have copies for NYLAG, a copy of the limited services agreement, and then also your checklist, please. And then, yep, you'll give it to me and you'll be good to go. Okay, thank you for your patience. I know we went over. Does anybody have any burning questions, or even not burning questions? That's also fine.
To jump out of the training, can you stay for us a couple of minutes extra to answer any other questions?
Hey, Wilma, I don't think we could hear that. Did you want somebody to stay?
Sorry, I'm just saying, if anybody here have questions, can you stay for another 2 minutes and other people can go?
Yeah, if you don't have any questions, you can feel free to leave, or if people have questions they want to ask now, you can feel free to stay. If you review the materials and have questions, you can also email me. I know this was like a lot of information at once.
Hi, Erin, we have a question.
Yes.
I have 2 questions actually. Will the client have any documents in place already, or are these all people who are doing it for the first time?
That's a great question. So the clients do not have any documents in place at this point. I don't believe Yeah, I don't believe any of the clients have any documents in place at this point.
Okay.
Yeah.
And then other question, if we don't think the client is understanding something, should we just err on the side of not having them fill out that particular section or form?
Yeah, I mean, you can, for sure, like if they're not understanding something, they should not sign. If you want
Like,
to
for
flag
example,
down,
if like it's the HIV concept is not clear, just don't have them initial that section.
exactly, yep, exactly. If that particular thing is not making sense or they don't understand it, then they shouldn't initial it. Yeah,
Okay, cool. Thank you.
And Erin,
absolutely.
I had not a question, but if you have any suggestions about working with divorced parents or separated parents, like what can volunteers, attorneys do if there's any conflict there?
That's a great question. So, number one, like, I think that's why we spend so much time kind of upfront emphasizing who the client is. It's the young person. So the young person is really going to be our guide in terms of like who we, how we're drafting these documents. And that is something that the client, the family members, if they stay for the consultation, are acknowledging that they understand. Nonetheless, if you have a parent who is kind of like dominating or not letting the young person be the guide for these documents, flag down Maria or I, and we are happy to run interference. I will say, like, I've spoken to all of the parents, I've spoken to all of the young people. People are on the same page, but things do come up, especially as you start walking through the documents. So again, it's whatever the young person wants. So like, the parents feuding is not really relevant. If they're feuding or like they're dominating the conversation or something like that, flag down Maria or I, and we will help kind of get the parent out of that situation so that the young person can make the document they want to make.
Thank you. Thank you. Thank you, everyone. If there are not more questions, I know that I will be sharing this recording as soon as possible so that you can review and the PowerPoint presentation and the all the forms I added to the chat. So thank you so much. And we hope to see you bright and early on Saturday. Make sure that you're there by 9:45 because that Erin usually do like an overview of what's going to happen on the clinic. So, and breakfast will be served. So I will see you there on Saturday.
Yep.
Thank you.
And yeah, thank you guys so much for attending.